to order the meeting of the Court Reporters Board. It's July 6, 2017. We are here at the Doubletree by Hilton, Ontario, California. Could you please do roll call?
Yes. Ms. Hurt.
Present.
Ms. Cronk.
Present.
Ms. Lisinski.
Present.
Ms. Nocella.
Present.
Ms. O'Neill.
Present.
Quorum reached.
Wonderful. We'd like to remind everyone that the proceedings of this board meeting are being recorded and webcasted. It's requested that anyone wishing to speak please come forward as they're recognized. It's welcome but not required that speakers identify themselves. So if we could please start off agenda item 1, minutes of the board meeting. Do we have any? Everyone's received a copy. Are there any additions or corrections?
You did a great job.
Well, thank you.
I didn't personally find any errors or corrections or anything, so.
Okay. So
I move to accept the minutes
any
for
further-
both.
For both. Is there a second?
Second.
Any further discussion? Public comments? Okay, hearing none. Call to vote.
Ms. Cronk.
Agreed.
Ms. Lisinski.
Yes?
Ms. Nocella.
Yes.
Ms. Hurt.
Yes.
Ms. O'Neill.
Yes.
Motion carries.
Okay. So that was approval of December 7th of 2016 and January 27th of 2017. Just so we're all on the same page. All right. Moving on to agenda item 2. This is a report from our executive officer.
So we are starting off with the budget report as we normally do. On page 23, you'll see the expenditure projection for fiscal month 11. We're pretty much on our regular course. Does anybody have any questions?
No questions on the budget report?
On the expenditure projection. If not, then if you go to page 24, you'll see our overall fund condition. And this one is remarkable in that it is different from the one you saw in January. When we talked about the license fee increase in January, the reports that we were provided by budgets did not include any transfers to the transcript reimbursement fund. So they have rerun the numbers, and that agenda item will be back before us again. We do have a representative from budgets on her way. The flight from Sacramento was canceled this morning, so she will be later. So I just would point out that last time when you saw this report, we didn't fall under the 6-month threshold until a year from now, but that's been moved up to basically the end of the last fiscal year, the fiscal year that just ended. So we will go into more detail when she gets here so that we are prepared to make the decision on the license fee increase. On the next page, on 25, is the fund condition for the transcript reimbursement fund. There's nothing. I guess I would turn it over to Paula real quick for an update on the TRF.
Thank you. For the per program, Ms. Davis has reported to me that there are approximately 20 apps in the queue. Some of them are waiting information, and a couple of them are ready to be approved. We have approved 161 applications worth $46,000 this year, and denied 24. So she has been very diligent and working hard to bring that program up to date. Unfortunately, the pro bono program is not quite as current. We are backlogged a couple of months. We have received quite a few more applications in the last fiscal year than we had received in the previous fiscal years. In fact, there were 501 invoices received for 2016-17 compared to 205 for the prior fiscal year. So it has been a little bit more difficult to keep up on top of those. I don't know if anybody has any questions, but I'd be happy to answer any.
I do. Have you gotten any sense of why such an increase? Is it in the sense of, is the word getting out, or?
I don't know how to answer that because this program's been in existence since 1981. And then a few years ago, Yvonne and I made efforts to, as you say, put the word out, advertise the TRF, if you will. We've had articles put in the association newsletters for the nonprofits. It's maybe something to that effect, I don't know. And I think sometimes there's a big case will come along, we get a bunch of invoices for one case, or maybe new staff are hired at an agency and they decide to catch up on the ones that are older. I really don't have any rhyme or reason to know why.
I have one thought. I know that I'm on the SDVLP board, the Senegal Volunteer Lawyers Program,
Yes.
and they're having to create more programs because there's a shortfall because of different government budgets, and they're looking to the court reporters to help with the transcripts when necessary. So I think that could be a reason for the increase of requests.
Thank you. Most of the cases that we get applications for are Los Angeles and San Francisco. We do get some from SDVLP as well, but a large portion of the ones we get are LA and SF.
Okay.
And what's the general reason why a transcript, just for my own education, when an application is denied? You said 24 were denied. What's the common theme of those denials, if any?
I'm not operating that program right now, but in my experience, there were denials when a person did not complete the application for reasons like no fee waiver was submitted. We do try to cure deficiencies, but there are some things that we reject an application for. We don't accept criminal cases. And if the person is represented by an attorney at the time that they apply, then obviously they don't qualify for the Pro-Per program. So we try to redirect them. We also have the addition of the vexatious list.
Vexatious litigant. Yeah.
Yes, vexatious litigants are no longer eligible for the transcript reimbursement fund. So those applicants are also being rejected.
Thank you.
Wonderful questions. We can move on.
Thank you.
Thank you.
And then moving on to our occupational analysis, I just want to update the board that the Office of Professional Examination Services is in the process of finalizing the verification, and then they'll create the exam plan. So they expect to have the March 2018 exams all be tied to the new occupational analysis.
And how often do we do this analysis?
Between 5 and 7 years is what the recommendation is, and we've been pretty much running about every 7 years.
Okay. Can you briefly talk about the importance of the analysis and how we use the information?
Absolutely. So when we do an occupational analysis, the Office of Professional Examination Services, it's OPES for short, they will convene a group of subject matter experts. So they get a variety of court reporters who will help them develop questions, and they do a survey that goes out to randomly about 2,500 CSRs. And that survey takes about an hour to fill out. There's a lot of information there, and we're just in a really good position that court reporters really care about their profession, and we get a really high response on that. So it makes the statistical validity really high. But the court reporters fill out information on what they need to know to do their job currently and kind of when they needed to know that. So it helps OPES identify what needs to be part of entry level, what you can learn later on the job. So it's really critical to developing the examination plan that then allows future workshops to tie the written questions into the exam plan to make sure that it's current. So there's no point testing new CSRs or candidates on how to change a typewriter ribbon, because that's no longer a part of what we do. So it's very important that we stay current with especially technology, but there are also practices that change over the years. So it's really important to keep that up to date. That's basically why it's so critical for us to make sure that we can guarantee then that the people passing the test truly are ready to take entry-level jobs in the field.
And if the board noticed that expenditure line item is larger than it's been for this reason, for the occupational analysis.
Yes, so that would be, I don't want to say a one-time thing, but it will be this year, and then we won't have to incur it again for several years. There's a couple of extra workshops that will be added into our regular development schedule, only because we'll take the existing test bank and see if any of them still apply, and we can reclassify those items and don't have to start from scratch with a brand-new test right from the get-go. They estimate that each question is about $10,000 of cost, so we want to keep as many as we can that are current and apply. And often a lot of the English ones, English will change somewhat, but there's not a lot. We can save a lot of the English.
It's a robust evaluation. Are there any questions?
Yeah, and just to refresh my memory, once OPSES has all this information, updated information, is this something that is then put up on the CRB's website as far as the results of the survey? Or, in other words, how does the schools get this information so that they can also look at that and make sure they're teaching the correct information?
Right, so we obviously provide that to the schools. I'm not sure in the past if it goes up on the website, it certainly could be. I know for sure that the exam plan that the tests are developed to are part of the PSI handbook. PSI is the vendor for our computerized testing. And so they produce a handbook, and that handbook contains the exam plan. So a candidate could look at that and say, oh, I see that 7% of the exam, just as an example, 7% of the exam will be vocabulary. So if it's a 100-question exam, they would expect 7 vocabulary questions. That's an example, it's not an exact percentage.
Well, to your point, Board Member O'Neill, maybe that's something that we would want to put on the website when we redo the website with valuable information that all folks can use.
Yeah, I agree, because I peruse Facebook frequently on the different court reporter related Facebook pages just to see what's the subject matter. And I see a lot of questions about California's requirements and about what California is looking for as far as testing questions, etc. And I think having it on the website would come in handy. I think it would clear up any misinformation that sometimes gets out.
I agree. Okay. Any other thoughts or questions? Okay.
So I'm updating you. The board did work with legal counsel, the legal affairs office, on requesting the permission to do an amicus brief in the Byrd versus Barkley case. It didn't get as far as the governor's office. It was turned down at agency level. So that will not be happening, and I have notified plaintiff that we will not be providing an amicus brief in that matter. As far as enforcement is concerned, we have the enforcement report starts on page 26, 27. I don't know if anybody has any questions. There aren't any trends, so to speak, that really jump out at us.
Have there been any ongoing enforcement complaints that you're dealing with that goes past a year?
Yeah, in the regular course of business, they do take that long to resolve.
Okay. I noticed that out of the 81 complaints that were investigated, 59 were closed with 31 remaining. And out of that 31 portion of folks, is that something we're waiting on information from them to provide, or is this a matter of having enough staff to take care of those issues?
Staffing is a little bit of it, but not very much of it. I think that pretty much it is waiting for information. Like any investigation, you put leads out, you ask questions, and then you have to wait for information to come back in. There is an element of due process that's involved, so people do have, respondents do have a certain time limit in which to respond. It's not like they need to drop everything and let us know as soon as
we call them. They
Mhm.
need time to prepare things, so
And we're meeting our times.
we're doing our best to meet our times. I mean, they're not languishing on our desk. I would say that we have one person that handles enforcement,
Mhm.
and so we are a little bit backed up in the cases where she takes vacation or sick, family emergencies, what have you, that then work does stop often on that desk.
Mhm. Okay. Any other questions? No? Okay.
Okay, moving on to the school update. I think everybody got the email that Sierra Valley College closed its doors, so we are down another private. I was also notified by Brian that they are no longer taking students in their brick and mortar locations, so they are all 100% online now. So that they've cut back quite a bit.
Can you remind folks how many schools we have currently? Is it,
It's on our website. Kim, do you know? Paula?
does anybody know? 3, 5? Private?
I believe there are 3 private.
Golden
And then, yeah, we have Golden State, South Coast,
and Humphreys.
and Humphreys.
And then is there 7 of the public still?
6 or 7. Like, I'm looking to Jocelyn, I'm sorry.
Somebody look on our website. It's
Okay.
it's 6 or 7
For all of California. Okay.
for all of California. I did get a letter from Golden State.
Mm.
And Sandy Finch just kind of gave us an update and said that their accreditation, she's cautiously hopeful. It is moving forward. I think that all of the board members know that court reporting programs do not work with the typical accreditors. We are outside of their parameters. We're on many different benchmarks. And so they are working, and it looks positive so far. And any of the schools that have asked the board for additional information, I've worked with Argonaut on getting them statistics. So the board has been working as requested with the individual schools.
Okay.
7 is the answer. Thank you.
Sarah Ann Chester. Yeah, Ms. Bruning.
So I recently spoke with the Bureau for Private Post-Secondary Education and found out that as of July 1st, out-of-state schools may register with them, which means that in order for them to offer online courses to California residents, they must register with BPPE. In turn, that means that court reporting schools could then become eligible to be recognized by our office even if they're out of state, if they're offering online schools and they're registered with BPPE.
Okay, so a little bit of light at the end of the tunnel,
Potentially.
potentially.
I don't believe that any of the online programs are teaching to our test. I think they are teaching to the RPR, which is a question and answer format. It's a 2-voice format, and we test at 4-voice. So they would have to make some adjustments to their curriculum before we would approve them.
Okay.
But it's an opportunity for change.
It's another avenue that people might pursue.
So I'm just kind of curious how, so they have this approval from some other bureau, but they still have to go through
Our law requires that schools, in order to be recognized, they have to be approved by WASC, Community Colleges of California, or BPPE, which is a bureau within Department of Consumer Affairs. So in order for us to even consider them, they have to have one of those 3 approvals first.
It's like,
But once they get that, they still have to go through something that their curriculum meets our standards, right?
yes. So
Yes.
they do the higher certification for things like financial aid and things, the bigger issues. But then once they pass that, then we take a look at their curriculum to make sure that it's in line with what we've set out in regulation.
Thanks.
We're frosting on the cake, so to speak.
Hey, Yvonne, is it my understanding still if someone passes an RPR in a different state, they're allowed to take the CSR?
It is one way to qualify to take our CSR, yes.
Because I think that's what a lot of the people are looking to do,
And
hoping.
I'm hoping that they can find good places for four-voice practice, because
too.
it's not an easy transition, as you know.
Yeah, okay, that's good to know.
So really, the largest hurdle for private schools and even public schools is accreditation.
Still, yes.
It's still a huge issue.
Without accreditation, then they're not eligible for the financial aid, which basically doesn't allow their students to afford to go.
Is there anything within our charter that we can do to affect change in this area of promoting or getting more schools online?
Well, I know Humphreys is now working on an online program. They've been working with Bryan University to use, I believe, their format for online. And they've been trying to help the Sage and Sierra Valley students transition so they can continue their coursework before coming to the test. So I guess it's just up to each of the individual programs whether they want to offer online,
Mm-hmm.
and then to have the means to do that.
And I also think about, going to our public schools like the UCs to see if we can promote more programs like this in their school system. I don't know if that's a possibility, but definitely as an individual board member, I think we should try to advocate for more schools. Any other questions? No?
Then the final item I have is a Breeze update, and I had a meeting scheduled but had to reschedule it. So coming up, I think it's on the 12th, I will be meeting with the DCA's Office of Information Services to find out what our options and costs are with regard to
Going on Breeze for licensing and enforcement platforms. There are also some of the other people that were in Release 3, the other boards, I should say, have been looking into individual vendors. So we talked just on a very high level of if there are several of we smaller boards that are looking to do something, maybe we could band together and get a better contract price. Very high level, very conceptual at this point, but I will be meeting, and so once I get more information, I'll be able to update the board.
So may I ask, so we're allowed to opt out of Breeze?
Yes.
Good.
I don't think Breeze is happening.
Well, Breeze is existing and it's working. I mean, there are
Not for the
Release
third,
1 and Release
3.
2 are up and running, yes. But 3, my understanding, and again, haven't had the meeting yet, but we'll be able to opt in, and there are costs associated like everything else, or there are some private vendors, and they're trying to work with everyone based on what we need, our business needs. Not everybody needs the same thing.
Okay, well then that's a different report from before, because it sounded
That's good.
like that was not going to happen at all.
Right.
Okay, great. All right, that takes us to agenda item 3, which is the license fee increase. But we don't have all of our participants.
We need our budget analyst.
Is she here yet?
No, she won't probably be here till 10:30.
Okay, what time? No, that's not anytime close. So if we could return to that agenda item and move forward to agenda item 4, which is legislation. Sub-agenda item A is the non-licensee-owned firm subcommittee report, AB 1660. That is sponsored or authored by Cora. I can give a mini report. It's been a very time-intensive process, amazing experience with a lot of writing and testimony. As folks know, we daylighted a lot of our strategic conversations to move forward to doing something about the issues of out-of-state firms or non-license owned firms following the Court Reporters Board's rules and regulations. We are the lead sponsors, and we have several co-sponsors in DRA and CCRA. At this time, we have one opposition, which are the out-of-state firms that are also known as California Advocates, Inc. We also had insurance companies that were originally in opposition, but then after meeting with them several times, they decided to remove it and understood what was really at stake and the process as it relates to them. Our EO was a huge part of them understanding what we do, so she talked them through the dynamics eloquently, and we should thank her. I was more of a fly on the wall, I think, in those meetings, because they really wanted to understand what's the process, how does it affect them, and so she was able to do that, and they pulled opposition. It has gone through the Assembly, and I'm happy to state that we were at the Senate Business and Professions Committee, and it's out of that as well with a passing on to appropriations. So we're taking little small steps, but steps indeed, and we'll update everybody when that is. We actually don't know when the Appropriations Committee will begin, but we are very hopeful that this is something that we can finish in this year's time, which is great. I think if I were to comment about the legislatures and talking to them, assembly members and senators, they're really starting to get what's at stake, what we're talking about, which is everyone following the same rules, regardless of whether they're an individual or a court reporting firm. And so that's hopeful. I know for myself, it took a time to wrap my head around what are the issues. And so for them, they're really understanding what we're talking about and seeing that it's an inequity and we need to make it equal. So I want to thank our co-sponsors, and I also would like to publicly thank Assemblymember Gallagher for taking this on with his strong leadership. He's done a great job. Board Member Nichella, is there anything that you?
No, I just, it's been a tremendous process, and I want to commend you, Chairwoman Hurt and Yvonne, for all of your hard work. It's been truly a journey. In my experience of sitting with the Assembly members and the senators, I've been very clear that this is not about a fund or a revenue generation opportunity. It is not that. It is clearly level the playing field and make everybody follow the same rules. And this is what we're charged with: protecting the consumers. We're charged with maintaining the integrity of the profession, and this wholeheartedly does that. And so I 100% stand by this bill, and I'm hopeful going forward.
It's been a great team effort.
Huge.
And I think I commend the board for having foresight to create a committee, because there's been a lot of after hours dealings, so to speak. So we've been as nimble as a state board can be on moving legislation, but our co-sponsors are helping us in that respect. So again, thanks to everybody for doing all the hard work. The staff recommends that the board receives the recommendation and the report and accept and file it, and to adopt the recommendations and actions of the committee as we've described. Would someone like to make a motion to that
I would like
effect?
to make a motion.
Is there a second?
I'll second.
All right, and then any public comments on? No? All right. And any further discussion? So if we could do a call to vote.
Ms. Crum?
Yes.
Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Thank you. Taking us to sub-agenda item B, which are the consideration of positions on legislation 1 through 16.
Yeah, at the beginning of every legislative year, there are lots of bills. So there are lots of them for your information. There are lots of bills that I'm tracking, but in particular, I wanted to have the board discuss the ones that are marked with the 3 asterisks, because they pertain directly either to the board or to court reporting. So the first one that I would put out there for discussion is AB 701 by Assemblyman Gallagher. This is a bill that is sponsored by CCRA that is contemplating the board licensing cart and captioners.
Okay, are there any comments? I think this is, well, I know this is on our strategic plan to happen. What is the status of the bill right now? I know,
It is in suspense. There is, as I understand it, there is a process that they're going to allow at the beginning of the second year of the legislative cycle. They're going to give them, anything that's in suspense, they're going to get a limited amount of time to basically come back out and get their votes at the committee level.
okay.
So in theory, between the time they went into suspense and then the beginning of the second year, they'll have time to cure anything that's holding them in the suspense file.
Okay. Do you know if there was any opposition or?
I don't think there's opposition. I think there are concerns with the costs involved. So we put an analysis together of what it would cost on board and board staff in order to have it move forward. I understand that the Judicial Council also, because it would require basically providing it for many judges who are hard of hearing, and just the scope of the court system across the state is large, and so the costs are pretty significant. But I don't know any details about negotiations or amendments or anything like that.
Okay. Is there a representative from CCRA that's here who could talk about the bill?
I'm here. I can give you the knowledge that I have. Brooke is on her way down on a flight from Sacramento.
Oh,
So
okay.
if you'd like.
Yeah, if you could come forward, it'd be great to inform the board what you do know.
Just so you know, my name is Jennifer Esquivel, and I'm the District D representative for CCRA, which basically encompasses most of Southern California. My understanding with this bill is that our aim is to provide assistance to those who are hard of hearing or have any sort of inability to hear the proceedings in court. From my recent understanding of emails and discussions I've had with fellow board members, there is very little opposition, with the exception of the cost. Obviously, given the court system and the state of the budget currently, that's going to be a challenge. But I've been told from discussions that it's currently, as Ms. Fenner indicated, in suspense. And I'm under the impression it's merely a formality of sorts to ultimately push the bill through at the end. I wish I could give you more information, but like I said, Ms. Ryan is on a flight down here and should be here in about an hour if you'd like
Okay.
to reopen the discussion then.
Okay.
Okay.
Thank you. Are there any questions or
I have
comments?
sort of a question. Isn't this an ADA issue? And, a disability issue, and so if that's the case, it would seem to me it would have some priority. Hearing impaired is, an ADA,
Can I respond
yes.
to that? I liken it, or I view it as really going along the same path of what they did with sign language interpreters. For years, the courts provided, in a very limited fashion, sign language interpreters in some criminal cases. Then that obligation grew into like family law cases, civil cases, etc. Then it grew into, through the Judicial Council, that these interpreters must be certified. And it's done through a process through the Judicial Council, a testing process, because there was no way to determine when an interpreter walked in prior to the certification process, whether they truly could adequately interpret, for the hard of hearing litigant or witness, or whoever needed those services during the proceedings. I actually witnessed a situation where I was a reporter during a trial where the defendant was hard of hearing, had a table interpreter. There were two interpreters to interpreting the witness for the defendant, and at least in our area, in Southern California, it is very hard to get certified sign language interpreters. And unbeknownst to the judge, they had that issue with this particular trial, and one of the interpreters was not certified by the Judicial Council. They had other certifications, but not the one that was required. And it became a huge issue when the table interpreter told the defendant's attorney that while the defendant was on the stand testifying in front of the jury, the interpreter that was not certified was not interpreting it correctly to the jury. And I know it's going to be a big issue on appeal. So but I digress. So I think it's the same thing. I know also in my court that when they do hire a CART reporter for hearing impaired people that do not know sign language, so they have to bring in a CART reporter. This agency that they have contracted with to provide those CART reporters use CART reporting students. They do not use certified court reporters. And that has raised some issues. One of my reporters was just telling me this week that she works in a family law courtroom, and there was a court reporter in there for one of the family law attorneys representing a client, and the judge and the hard of hearing attorney was going back and forth based on a misunderstanding caused by the student who's doing the captioning was not accurately writing what the judge was saying. It was not translating correctly.
It sounds like you're supportive.
Oh, I'm very supportive.
Okay.
Yeah. So, I mean, so that's why I'm saying that it's not just an ADA issue. The issue is certification.
Oh, no, I get that, but my understanding is that issues that are ADA tend to get a high priority in legislative circles.
I think the budget is a huge
Well,
issue, and there are a lot of high priorities.
no, I
Yeah.
get that. I get the high priority, lots of them. I'm just saying that it's a constituency that,
Yeah. I think where the issue is, and you're right, it is a high priority. My court knows that they have to provide a card reporter if the litigant does not understand actual sign language. However, my court HR department complains about the high cost of providing a CART reporter, and they'll go with the cheapest they can get. They don't care about whether this CART reporter is providing adequate service to the level that is needed. And so this is the certification that would cure that issue.
so are we looking to support?
There's several things we can do. One of those could be to support the bill. Another is to watch the bill since it's gone into suspense, and just keep a close eye on what's happening with that bill. And when it returns to being ripe again, so to speak, we can chime back in on what we think and how we feel at that time, especially with any language changes that may happen or occur over time. Sure, come forward.
I'm sorry, Ms. Lisinski, just to kind of touch on what your concern was, I just wanted to share, and I'm not sure if the board's already aware of this, one of the key targets of the bill is to make sure that there's a difference between a certified shorthand reporter that is sitting in the courtroom to report the proceedings as opposed to an individual that's been assigned to a litigant or a party in the courtroom who is merely providing the interpretation for the person or the individual. There's been a lot of discussion within CCRA about making sure that any service provided in this manner is of high quality, so to speak, and we want to make sure that whatever certified shorthand reporter or whoever is assigned to the courtroom is not also tasked with the same responsibility of providing the service to the person that's in need. So that's one of the things that CCRA has attempted to emphasize with this bill, because we don't want to make it a, so to speak, 2-for-1. And we think it's very important that whatever person or individual is in need of the service is getting, as Ms. O'Neill indicated, a high-quality service, and is not being shorted in terms of what their understanding of the proceedings are. As you may very well know, there is a difference between providing a verbatim record, which certified shorthand reporters do, and providing a card or captioning service of something on television or something for the hard of hearing. So we want to make sure that with this bill, it's clear in the language that there is a difference and that you cannot rely on one reporter to kind of provide every service within a courtroom, if that makes sense.
Sure. It's a very complex issue with many stakeholders and many moving parts. And
If I could just clarify for Elizabeth, that a good example for somebody that's outside of the profession, the certified court reporter will write verbatim, and we
Right.
write words, we write whatever is spoken. So the court reporter, it's more important that you get an understanding. So if somebody drops something and there's a loud noise, they put parentheticals in. If people start laughing, they put parentheticals in to bring that hard of hearing person a fuller understanding of what's actually happening. Those are things that they would be denied if they were only getting the verbatim transcript feed from the court
Okay.
reporter. So there's an essential difference.
Right, okay. Thank you.
And if you'd like, Ms. Lisinski, I can speak with Ms. Ryan when she arrives and find out what involvement the ADA has currently, if any, in terms of their communication with CCRA about the bill, and if they've provided any assistance, and I can definitely get back to you.
Yeah, thank you.
You're welcome.
Somebody-
And from the board's perspective, first and foremost, we should be looking at consumer harm on whether we support this or not. And you can definitely see it,
Right.
but we're not there yet. Hi, welcome.
Hi, good morning. My name is Anna Costa. I'm a retired court reporter, and I do many things. Educate court reporting students, train them, coach them, provide internship opportunities for them to be reporter of record in mock depositions, mock trials, and also educating the legal community about what we do. Regarding this issue, I have mixed feelings about it. I know several of my students who are doing CART, and they started at 180. The concern, as has been mentioned here, is that they are not writing verbatim, they are writing the gist, basically. And so they are self-correcting as they are writing, as opposed to a verbatim reporter who writes exactly what is said. And from my discussion with these students, and when I offer coaching sessions, I ask several questions, and what I hear from them is they are not passing the CSR because they are self-correcting. It is a habit. I mean, it's something, a skill that they have learned to do when writing CART. And it's hard to break, especially in a testing environment. So really, everything that I've heard from CART reporters is you need to write a minimum of 225 words a minute. Minimum, really above. Because the people on TV or events are speaking way faster than 200 words a minute, definitely more than 180. So you mentioned, Tony, family law, and that is of particular interest to me, and I've been working with CCRA regarding the latest round of the budget push, writing letters and forwarding letters to get court reporters back in the family law courts. And so I'm writing an article about that and the results, and I got information from the Judicial Council about it. So it is really, really important, as was mentioned here, that in educating judges and lawyers, that they are very, very clear, and maybe the language needs to be changed in this bill, but they really need to get that the CART reporter is not the official reporter in the court. So Thanks
Thank
for
you.
listening.
Yeah, thank you for your testimony.
And just as an update, this week, San Diego stopped providing court reporters in all family law courtrooms.
Stopped?
Attorneys need to bring their own for hearings and trials.
Can you
Oh.
speak up a little?
I'm sorry. This week, it was announced that all family law courtrooms in San Diego County will no longer have court reporters provided by the courts. That if an attorney wants a reporter present for hearings or trials, the attorneys have to hire a private reporter.
Oh. Did we get any correspondence on that?
I did not hear that.
And to my knowledge, there were no layoffs. They moved people around and paid people to retire early.
Yeah, and they were not, I saw that too. They are not using pro tems anymore or retired officials anymore. What I surmise from that is that the reporters that were working in family law are going to absorb
That's to my knowledge.
Into other areas.
that. Mhm.
Sure, absolutely.
Sorry, I forgot to say why I have mixed feelings about it. These students that I know who have worked with me and on internships, this is how they're making a living.
Mhm.
So if they need to be accredited or to be certified, that's going to have an impact on their income, paying off student loans, et cetera, or they timed out at the school.
Okay, thank you. All right, so it doesn't sound like we're ready to move forward with the support, or we're gonna sit back and watch how the bill moves.
Yeah, because, I mean, like for just on me, on a personal basis, I'm supportive in concept. So I guess that would translate into watching.
And
then-
hoping.
Watching and hoping. Okay, so the next bill we should review.
On page 37, AB 1285 by Gibson. This one, currently, hearings that are done before the Alcohol Beverage Control Board are, use certified shorthand reporters to report those hearings. This bill would allow for audio recording.
Okay, any discussion from the board on this, particularly from our CSRs?
Yeah, really.
Where should I begin? No.
Uh-oh.
As far as, since our mission is to protect the consumer,
Mhm.
I would think that as a board, we should probably submit a letter against, that's the word I want to use, against this bill.
In opposition.
as-
Opposition?
Yeah, in opposition, thank you.
Yeah.
I knew there was a word I was missing. In opposition of this bill as not protecting the consumer.
Okay, any other thoughts?
Yeah, I
Okay.
believe that there's a lot of information nationally, internationally, as to why it is always better to have a certified shorthand reporter as opposed to a tape recording, if you want a good record.
Yeah.
So for sure, to protect the consumer, I agree with Tony that we need to write a letter in opposition to this bill.
I agree as well. I mean, as it's been said, protecting consumers and the consumer harm that can come from not having a correct record, so to speak, is very damaging for people in their lives in an appeal setting. So, and here we're talking about Alcoholic Beverage Appeals Board, so.
And you could, yes, and you could see where that would go mightily wrong.
Where it could go very wrong.
Really.
So, I hear two folks interested in writing a letter in opposition. Is there a motion that anyone would like to make?
I so move that we write a letter in opposition to this bill.
Public comment?
You need a
I'll
second.
Oh, sorry, second.
Second.
Okay, and then public comment? No? Further discussion amongst the board? All right, it's roll call.
Ms. Crom?
Yes?
Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Okay.
So the next bill that I would have the board consider would be also on page 37, AB 1450 by Assemblyman Obernolte. This one is also sponsored by CCRA and is contemplating electronic transcripts being filed in court. I would just note that quickly, above that AB 970 by Berman, that also has an element of electronic filing. However, it's more of the Judicial Council's omnibus bill. There are 20 pages of many things that the Judicial Council is moving. And for that reason, I've kind of left that one alone, but moved to 1450.
Okay. Well, it definitely saves time and paper.
So, may I ask a question? And, sorry, Jennifer. It's, I think CCRA's bill.
No, I'm gonna bring my phone with me because I have all the information.
Okay. So if it requires that the court reporters or the transcripts be delivered in electronic form, or that's an option, that would no longer necessitate the sealing of the original and providing that in court?
Correct, that is my understanding. It would be uploaded electronically through a vendor of the reporter's choice and therefore filed with the court in that way as opposed to a paper copy sealed.
Okay. Interesting.
And may I make the comment that when I became a reporter in 1981, the court was not allowing transcripts to be filed with the court, even sealed. So.
I'm not sure I understand. Can you
Well,
elaborate?
Well, you're talking, okay, I was talking on the local level. So this is talking about for the District Court of Appeal or for all courts?
Superior Court.
Superior Court,
My
District
understanding
Court of
it's the
Appeal.
Superior Courts. I believe that the District Court of Appeals is something that we're currently working on to include, but haven't formally included it.
And, the District Court of Appeal are the ones that would do it in a second.
Right.
Yes.
Well, and our hope is that this is
Mhm.
going to not only save paper and ink, but also kind of solidify the integrity of the original transcript and make sure that it is filed and lodged with the court appropriately, and that the reporter is the one that actually does it personally, as opposed to it being in someone else's hands.
Can I ask a question?
Absolutely.
Are there any issues with the potential hijacking of that document and
The paper document?
No, the e-filing of it when it's.
No, my understanding is that the server or the vendor that the reporter would use would provide a secure way of uploading that information, and that it would comply with any sort of confidentiality. I mean, this day and age, we have things like HIPAA to consider, and this would be something that would allow reporters to avoid any issues with having to find a secure website or online program to do it, or simply emailing it, which we never want to do. So that's something that we have taken into consideration. I can tell you that among the vendors we've discussed this service with is Yes Law, and we've taken time to go around the state. Brooke Ryan, our president, as well as other advisors with CCRA, have gone to the individual counties and put on presentations to explain to the reporters exactly what this would entail, as well as the cost-saving portion of it. Not having to worry about the original being left with an attorney and a deposition, et cetera, because you would be the one providing the information to the court directly. So essentially, there is no language currently that mandates that the reporter use a specific company. This is something that I believe we've stressed is up to the reporter. CCRA has explored how this would work with certain vendors, but in no way are we emphasizing one over the other. And we do believe that it would be a minimal cost for the reporter to put out in exchange for being able to upload these items electronically. And given that officials in courts are often 1099 in terms of transcript production, that would be something that they would then use as an expense for that portion of their income.
So, oh, sure. No, go ahead. I'll wait for my question.
So I don't know, this is really good, it's smart, it's, the thing is that it's gonna really affect 2025 510 and the sealing and the filing and a lot of the CCP right now. So does this bill go into fixing some of the problems that's gonna be in 2025? Because
What problems specifically are
for
you thinking of?
instance, you know, how a person reads and signs,
Mhm.
and the read and sign the electronic version, since there's gonna be no paper.
Correct.
That's just one thing, I'm just talking out loud.
Well, I don't believe that the code currently mandates that an actual written hard copy be reviewed by the witness. Am I correct in
Absolutely.
that?
And if you read that whole section, there's some
Mhm.
confusion as to what the alternative is able to do as far as
Okay,
the fix. And we could talk about later, I don't want to take
Sure.
up the time of the board.
sure.
But I believe that there's some things that can be fixed because of this in there that will make it a lot easier and more seamless for all court reporters and for the judges and the attorneys. Because it also affects the
Right.
SoCal step. That is a big, you know, conversation
Right.
here. So, like I said, we don't necessarily have to talk about this right now, but I think that there's some opportunity, if this does go through, to fix some different things that are happening in our state.
Sure, I believe I understand now where you're going with that. And yes, we can most definitely discuss it. I'll be here overnight for the exam, so you're welcome to stop me at any time today or tomorrow and we can talk about it.
Yeah, I believe both CCRA, DRA, and all court reporters in California would have a reason to support this.
Well, and I would just like to give a personal anecdote to the board to emphasize why I feel personally as a freelance court reporter in the deposition world that this is so important. I recently took a deposition that was 2 volumes of a pro per plaintiff who was suing a very large medical facility. And it was a videotaped deposition, and the gentleman clearly, when he arrived, was not in a calm, cool, collected manner. That's the best way I can describe it. And at the end of the deposition, I was horrified to hear the noticing attorney stipulate to give the original to this witness for read and sign, and basically probably never see it again. And we've had this discussion many times with attorneys and their ability to do as they wish with the original transcript and whether the reporter follows along with that wish. I'm sharing this with you because I immediately contacted the Court Reporters Board and expressed my concern, almost from the standpoint of trying to protect the consumer from himself if he's going to get his hands on this original transcript and be the sole responsible party for it. And true to form, when I showed up for volume 2, he claimed he still had not received it, wasn't sure where it had ended up. And so this bill, I would hope, would basically remove any option for that to happen again, because obviously as the licensed court reporter on the case, I was very concerned where the original transcript had ended up. However, I felt my hands were tied to a certain point because I wasn't sure how to argue with an attorney there on the record, on video. I mean, we certainly could have gone off the record, and I did express to her once the deposition ended my concern, but I think the damage was kind of already done at that point, as the CRB agreed with me that it was kind of said and done. So I think that this is important because it will alleviate some of the stress of not being able to handle the original transcript itself. As a deposition reporter, I hear stories all the time from attorneys in front of me sharing with their clients some amazing stories, I will say, about why court reporters don't like to not be handling the original transcript. And a lot of them are untrue. I'm not sure how that ended up happening. But I always just try to emphasize that my concern personally as a deposition reporter is the integrity of the original transcript, and my certificate for making sure that that original transcript is true and accurate is going to be null and void if it ends up in the wrong hands and is dismantled or something to that effect. So I would hope uploading it electronically would solve that.
What's the status of the bill right now?
So that's why I brought my phone up. So
Been re-referred to appropriations.
yeah, okay. Thank you.
I checked it yesterday.
Oh, you beat me to it.
All right, thank you very much.
You're
Thank
welcome.
you.
Are there any
Yes,
other
ma'am.
questions?
I don't believe so. Thank
Okay.
you very much. Does the board have a position they'd like to take today on this bill, or would we like to have another sit and wait and watch in light of the status of the bill and where it stands?
Yeah, I'm more inclined, I mean, personally, this is the first step to the future. I mean, it's inevitable. However, being so brand new, I want to, and I am sure that what we are reading today is not what we're going to be reading down the line or when the governor signs it. Because I think eventually the governor's going to be signing something.
Yeah.
So, yes, again,
Watch the evolution of the bill.
yes.
Watch it.
Okay.
And I don't know, I'm sorry, I haven't read it specifically, the bill itself, the language, so I'm gonna do my homework.
Okay.
I know exactly what it says.
Yeah, we had a lot of legislative bills on this agenda, so.
I just want to say, I mean, I think this is a one-year bill, if I'm correct, right? So its terminus is coming up soon. So we won't have the opportunity to weigh in as a board unless we meet again and have this conversation. I'm inclined to move to support the bill because I think it's the right thing to do, and it's so far along the legislative process. But I am one of 5, right? So, but I do think that we're not going to have the opportunity to come and have this conversation until the bill sees the governor's desk.
This year?
So,
Oh, okay.
would you like to make a motion?
I'll
and
make
see
the
if it
motion
goes-
to support AB 1450.
Okay, and is there a second?
I'm gonna
Second.
second it, or,
Okay, you can.
but then may I ask a question because you know more than I? So if, let's say we support it now because we want to, but then if the language changes, can we take our support away later if necessary?
It's always a case of you support or you oppose at the time, the language at the time. So every time
Okay.
it's amended, then you have to check back
You
into.
have a new opportunity.
Absolutely.
Then it's perfect.
So would it be permissible to give the executive officer or the chair the authority to remove our support should the language substantively change past the point at which we deem is the primary function of the bill?
So I think that would be a council question.
Yes, so long as you imbue that power into a single person, yes, you may do so, as part of your motion.
Oh,
So would you like to amend your
Yes,
motion?
I will amend my motion. I move that the California Court Reporter Board support AB 1450 in its current format. And should the format change substantively and deviate from the existing language, I hereby empower
Executive officer.
the executive officer to remove our support of that bill.
Is there a second?
I second that.
Okay.
That's a great question.
Public comment? No. Further discussion? All right, let's take a roll call.
Ms. Crum?
Yes.
Ms.
Yes.
Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes,
Motion carries.
slowly but surely we got there.
Before we move into the last bill, could we have a comfort break?
Oh, absolutely.
Oh,
A 2-minute comfort break, please.
2 minutes.
Thank you.
Wow.
Is everybody ready?
Yes.
Okay, Court Reporters Board is back into session. We were in the middle of Agenda Item 4, legislation, and we have one more the board should review in greater detail.
So SB 76 by Senator Nielsen would, in certain cases for Department of Human Resources PERS, some of the arbitrations that are associated with those bodies would allow the moving parties to hire certified shorthand reporters to create their record. It's not a mandate, it's a permission, I guess. They're allowed to do that if they'd like to.
So it's an allowance. Okay?
May I make a comment?
Absolutely.
To my understanding, many times in this situation or currently, the arbitrator will have a tape recorder, and that's the official record, even if the parties hire a court reporter to create a record. And so then the court reporter becomes a note taker. And I think that we ought to support this bill because to give permission for the court reporter, if there is one present, to become the official record and not be forced to use that tape recording, because it usually it's very bad. The arbitrators are messing around, you can't really hear, and for the court reporter to be competing with that when they're sitting there is ridiculous for the consumer.
Is there an association that's sponsoring this that we're aware of? No. Okay.
Oh.
Are there any other comments related to this bill? So it sounds like I hear a support.
Can we?
Yeah,
I would like to, I don't know enough. It would seem to me that this would be something we would want to support,
But I'm not an
Are there
expert.
any questions that could be answered to help you get there? Or, I know because we're not court reporters.
Yes, I feel like it's not my expertise, so
I have a question.
there you go.
Sure, would you like to come forward and give testimony?
I just had a quick question regarding Ms. Cram's comment about the electronic recording being the official record, and hopefully you can answer this. In that instance, who would be transcribing the audio file? Do you know?
Yes, usually, what happens, as a court reporter, they can give you that audio file and say,
Correct.
okay, this is the official record, and that puts tremendous pressure on this court reporter making notes. But they'd have to hire an outside party to, again, create another transcript on that audio.
Well, and my concern would be if that transcript is going to be peppered with parentheticals such as inaudible or indiscernible or simultaneous speaking, something to that effect, which I think we all believe would put the validity and accuracy of the transcript in jeopardy for the consumer.
And what I would suggest is this says transcript would be the official record if they choose to have a court reporter there. I'm just saying,
Correct.
if they don't have a court reporter and they have a tape recorder, okay, that might be the official record. But to have a court reporter sitting there creating a verbatim record, and then not to be the official record is a waste of
Resources.
money, resources, and a good record.
So
Correct.
there's options, and it's a better option.
It's a
to
better
have
option to have that opportunity because now our hands are tied. And so if the attorneys do choose to have a reporter because they want a rough draft or immediate copy, it's not the official record. And so I termed it, we become note takers. We're the fastest paralegal you can find to create a transcript. And then the other thing is that we're not allowed to provide or sell that transcript to the other side because you're only hired by one person. It's not the official record.
There would be no certificate
So there
at
are
the
many
end.
reasons in my mind that we would support this, and I think it would help the reporting industry, help arbitrations and the arbitrators and the litigants tremendously.
Yeah.
Because now their hands are tied.
Yeah.
Yeah, and I would agree with Rosalie, because just from the fact that it says, in addition to the right of, bringing a CSR in to transcribe the proceedings, for me, the key language is transcript shall be the official record. So that takes care of any of the tape recording issue. And I think that's a direct protection for the consumer, is to have that certified transcript versus somebody's, a transcriber's best effort.
It fixes a problem.
Understanding
I
an
think.
audio.
It fixes a problem.
Well, and my question would be, if it's not the official record that the certified shorthand reporter is producing, then would there be any code or statute that would mandate that they hold on to those notes or that unofficial record for an extended period of time? So if 2 years down the line someone wanted something transcribed, the reporter would not be under any obligation to actually
No.
follow
In
that.
my mind, it becomes work product for whoever you hire.
Correct.
Okay,
Thank you.
thank you. Any other questions? Sure, go. Okay, so it sounds like there's portions of the bill that you support. Do
I
you
would
support
support
it
it.
in its entirety?
Some of the language is tricky.
Okay.
About who's going to pay for it. And once again, I apologize, I don't know the bill that well. I don't know who the author is, since there's no CCRA or DRA person. So what would you suggest, Yvonne? Maybe we should just watch it? But I can pay attention, or we can ask someone to really talk about the dynamics of this bill, the motivation.
Actually, from my reading of the bill as it is right now, I think you hit it right on the head. I think that it's really important for consumers to have a better option. As you said, the reporter is there. I mean, it's not up to us to figure out who pays for it.
Okay.
That's a different thing. But the best available record for the consumer who is relying on that for all purposes, if it's important enough to have an arbitration, then it's important enough to have a record. And
So-
it's not mandatory, you're not making somebody pay for something, but if they want that, it should be available.
And I feel strongly about it, so I would like to make a motion that we write a letter in support of SB 76,
Okay, is there a second?
as the language reads at this time.
Thank you.
Thank you.
So second, public comment. Okay, and any further discussion?
I wonder if Board Member Crum would want to have the same amendment that Ms. Nocella did. that
As the language exists now.
As it exists now, and if it changes substantially, that you would want me to make it known to
So
the author's office that we would no longer support if
Correct. I would
goes
like to-
south.
I would like to amend my motion to include that language.
Okay, so there's an amendment that we support the language as is, and if there are substantive changes, the EO will take steps to either continue support or change our position. Do we still have our second?
Yes.
Okay. Any further discussion? Okay, seeing none and no public comment on the item, let's take vote.
Ms. Crum?
Yes.
Ms. Lisinski?
yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
Okay, more options. So we have gone through, are there any other legislative items that you would like to discuss or shine light on that we haven't already? Okay. So I don't think we have our other member for agenda item 3, so we'll continue on for agenda item 5. It's the consideration of the retired licensee category. At our September and also our January meeting, we talked about this subject and putting it back before us today after our executive officer did a little research on the status.
I would like to take credit, but it was staff.
Oh. Shh.
Specifically, Ms. Davis helped me a lot on doing the survey of the different states that have licensing. What she found out, what we found out, is there aren't that many states that do licensing. Of the ones that do licensing, few of them have the retired category. The ones that do have a retired category do allow you to unretire, so to speak, or become active again if your fees are current and any continuing education requirements are current.
Okay.
But it's skinny data, so I don't know that it's statistically significant for this board's decisions.
So there were kind of 2 general areas that we were concerned about. We were concerned about general licensees and their future, and then we were also concerned about how it relates to the executive officer and the North Carolina case. And the executive officer being able to retain her license and also work for the board. Do we have any
With
details?
regard to executive officers being licensed members of the profession for which they serve, I believe the last update that I have on that is that we're sort of in stasis with regard to that. Legislation is being contemplated, I understand. I don't believe there are any pending bills with regard to that. You are not the only board that has a licensee as an executive officer. However, I don't believe you are statutorily required to have a licensee as an executive officer, whereas there are several boards which have statutory mandates to have licensees as their executive officers. The issues related to the North Carolina case are evolving. This is by no means a clear set of facts that we're working with. Case law is developing around the nation, literally as we speak, with regard to state licensing agency litigations. Last count, I believe there are around the nation 15 to 20 antitrust cases pending. Some are resolving very early on as being not within the confines of antitrust. Some are resolving through changes or modifications to state law. Some are proceeding through the litigation process. So it's difficult to say right now today. A retired status for your EO may be sufficient. It may also not be sufficient. The way the case was written gave some guideposts, but not a lot of detail, which as I am speaking to some attorneys here, you recognize that that's what we deal with when we're dealing with Supreme Court case law.
Absolutely.
So the recommendation, if you had a retired status, the recommendation would be for the EO to take retired status, because at that point it would be at least the most you could do without changing your EO, and bringing the acquired knowledge of a career to the industry. But I can't tell you that you have to go forward with retired status in order to give your EO that option. And frankly, if that would be the primary reason for doing it, I would recommend against it right now.
Okay. Okay, and so that's one bucket we have, and the other bucket is general licensees and their future and importance with a retired status. Are there any board members that have strong feelings for moving against? I know from my perspective, resources and staff time is really important. We have a lot of balls in the air, so to speak.
Really?
So I don't know if we could take on this topic at this time, but it's good to talk about it, and I'd like to hear where other board members are.
I can see sort of a smaller segment where this could apply as far as retired official reporters and still producing transcripts and being able to certify them as a licensee. However, in the overall scheme of things, as far as the percentage of those licensees that might opt to do that versus the total number of licensees, it's not going to be a large number. And so I hesitate to undergo all of this for the amount of work it's going to require when it is not going to impact, even get to the 50% mark, of licensees. I would suggest that maybe what we do is sort of watch this possibility as we go along, because we're just now starting to really see the reporters retiring. I think we're going to see the huge wave in about 2 years, and see if the need is really there.
If we, how long is the regulatory process?
So
Probably a year.
in the past, I would have told you a minimum of 6 months. In light of North Carolina, one of the things that the department has changed in order to provide the oversight that the court indicated was required is that boards promulgating regulations are now treated like bureaus. Before you can notice the regulation, you have to go through a pre-approval process. That can take anywhere from 3 to 6 months, and then you notice the regulation, and then you have to go through the statutory process. The fastest that you can get through the statutory process is your 45-day notice period, plus the review time for OAL to review the final package, and that's 35 business day or 30 business days. So it's 45 calendar days for the notice period for the public, assuming no changes based upon the comments, once you've completed the response to the comments, submission to OAL, and them completing their review within 35 business days, which works out to closer to 45 days. The fastest I've ever seen a regulation go through the entire statutory process is about 120 days.
Okay.
And that's after you go through the pre-review process.
That's-
And
yeah, it's
again, that
quicker than I
is
thought.
quick.
It's
That is
quicker than I
quick.
thought.
But usually that's, you know, when there's a lot of manpower behind it and there's either little comment or it's non-controversial. In the standard, I would tell you that you're looking at 6 to 9 months after you notice the package.
Okay,
May I make a comment?
absolutely.
Now that North Carolina is not that important, not the state, anyway, in my mind, I know many court reporters who are retired, and I don't know that they need a status. We know, they let the world know, and I think it's just gonna cost us money and time, and so at this time, I would suggest that we just not pursue it. We could watch and see if something comes up, but I can't imagine why a reporter would need or want that status at this time.
I agree with you. One additional question I have is, don't we have an inactive status in our?
No. So you either have a current license, or it's delinquent, or
Okay.
it's canceled.
How many years for cancellation?
Well, there's voluntary cancellation, cancellation for disciplinary purposes, or after 3 years you don't
3
renew,
years, okay.
then it's an automatic cancel.
So where did well, you probably won't know, but I heard discussion or talks in prior meetings about language that we have on the boards for inactive status, but we don't have anything implemented.
I mean, I'm sure
Like
that
it's possible?
It's possible to note that, but you would need to do regulations to define how you would get into that category
Okay.
and what that category meant.
Okay. Are there any public comments on this topic?
Hi, it's Anna Costa again. So my current status is canceled, and I haven't been active since 2008 was when I finally let go of my license. I would prefer to be either retired or inactive, because anyone who looks at canceled, especially because I am out there doing work involving core reporting, they may see it as a negative connotation, like why was she canceled, as opposed to inactive. I don't know who chooses the designation or how that is, but if it's going to cost a great deal to get another status called retired, then obviously it's going to have an impact. But that would be my preference, not to be canceled.
Okay, thank you.
Thanks.
I'm not asking for more work, but I am sympathetic because staff says, why don't you let your license become delinquent? And it's just a matter of pride. I don't want people to look on the website and say the executive officer's license is delinquent. It makes it look
Right. I
like I didn't
understand.
pay my bill.
Yes,
So
I understand.
I am sympathetic to Anna's point.
And I am too. I really am, because it's what your profession is and what you've done for many, many years, and you pride yourself on job well done. And to see canceled, I'm sure, doesn't feel terribly good. Is there any way to change that label from canceled?
To retired.
To give it to it, yeah.
Other than
Back to
retired,
the-
so that we don't have to go through that
Yeah.
regulatory process?
Just as a
Is
point
it
of
semantics?
clarification, people can renew, like Ms. Finner said, within 3 years after the license it hasn't been paid or is in the delinquent status. If it's canceled, it's gone. There's no bringing it back and changing the status title. So that's the same status, like Ms. Finner said, for those whose licenses may have been revoked. If the person has been deceased, anything, so it's just gone. If they want to be licensed again, it's a reapplication to the examination. So I believe if you are considering a retired status, it would be an option for people who are currently eligible to renew.
Thank you. Any other comments?
No, but I understand what you're saying as far as changing the classification, the wording of it from canceled to have it say inactive or inactive hyphen for some reason.
Right.
As opposed to, because I agree with you, when you look online, people are going to question, well, why? What did she do? Why is it canceled in your instance when you just stopped paying? So.
But isn't just even changing that word, that still puts us in the position of having to to go through the regulatory thing?
Well, maybe our council can answer that question. I'm
So
putting you
there's
on the
several.
spot, sorry.
That's all right. There are several. Your specific question again was?
Well, so she was saying, well, can we just relabel
Canceled.
The problem is with that is that retired usually involves an election by the licensee. If somebody allowed their license to lapse 10 years ago and there was they made no change with regard to the status, we don't know why they did that. We don't know that they retired. We don't know that they would have elected to retire had they done it. There may be a way. Right now in statute you don't have the authority. I would have to look at the statute as it was written that authorized retired status to determine whether or not it would be broad enough for us to try this, to allow anybody who does have a current status canceled to apply for retired status, meaning we can look at them and see whether or not there's any reason why, if they had renewed when they would be subject to discipline, we weren't investigating.
Right.
Some people allow their licenses to lapse because they know that they're going to, and don't renew because they know that they're going to face disciplinary action. So there are many reasons why just simply converting everybody who's canceled to retired wouldn't work.
Well, no, and she's saying
So,
that.
I'm saying inactive. Giving it a different label.
The
that
brand
other
is a
than-
little, it's a little friendly.
And that would require statutory change because right now,
So right now, it seems it's a default label that just says
Canceled,
canceled.
yes.
Now, is that because of the program, the technology, and that's the name that they gave it, or can we give it a different name?
it's not just because of the program. There is an inactive status that you can apply for. There's usually an ongoing fee, some portion, it's a reduced fee amount. Some boards have a reduced fee, some boards have no fee at all. Retired status usually has no fee. There's a difference between inactive status and retired status legally. In inactive status, the board retains jurisdiction over any conduct that you engage in during your inactive status, which then when you reactivate could lead to discipline. There's and I don't know that it's necessarily been changed. The case law in question is some years old now, which is why retired status didn't move forward sooner than now for all boards. Is that there have been some adverse cases in the earlier 2000s for retired statuses where the court suggested that once they became retired, that the conduct that occurred during their retired period of time couldn't be used against them for discipline should they reapply for a license, because the retired status removes jurisdiction. And so there may be some options under some circumstances for some licensees, but there's not a way that I can see under the current statutory scheme for you to convert everybody from canceled to inactive.
But we don't even have an inactive
Yeah.
category.
Yeah.
And that would require regulations.
It sounds like any change we make is going to require regulation
Exactly.
change. I was just hoping that we could get around the semantics of canceled
Well-
to put some other label, but it's okay.
Right,
The
and if
word.
they're already-
Yes, the word.
That's
Words
all.
matter, actually.
And if they're already out of the system, we cannot re-enter them unless they want to go through the whole process again, and that doesn't sound appealing. So,
May I suggest, and I think it's on the website, the name and canceled, let's say, put an asterisk, and then say, may mean retired. Retired.
Okay.
You
Just to
might
make
want to
people-
look at whether or not when
Without
you
going
have
through
a
the whole
canceled
thing.
by operation of law versus a canceled because of a
Disciplinary.
disciplinary action, that you
there may be a way for that mark to be added to your database, so that when somebody looks up the license, it indicates that it's canceled by operation of law due to expiration, non-renewal, which
Yeah.
has a little bit less
It's a
stigma.
little friendlier.
Yes.
That's right.
Right.
Okay, so we can look into that, I think. Yes.
Done.
So there's,
Added to the list. Sorry.
at least it's not retired category.
It's not reg.
Right.
It's not a reg. Thank you for your testimony, by the way, thank you. All right, so, did I see someone from budgets coming? There she is, okay.
Oh.
Yeah, if you could come forward. So we'll return back to, let's see. Thank you very much. Where I wrote skipped, yeah. Agenda item 3, the license fee increase. So if Yvonne, could you just give us a brief summary to get us started, and then we'll go?
So I mentioned for Marina's benefit, welcome by the way.
Thanks.
The information that the board used as a basis to make their decisions on the license fee increase did not include transfers to the transcript reimbursement fund. And so Marina agreed to come this morning to answer any questions that the board had, explain maybe anything that would help us understand, but we do need to revisit the amount and when the license fee would go into effect.
Are there any questions from the board members of Marina before we get into any comments? I have a few. No questions, so I'll start off maybe.
Sorry, just, I don't mean to interrupt.
No.
Did you guys already kind of discuss the fee increase, or is this the first time you're?
We actually
Okay.
waited so that you could
Oh,
fly in.
I'm sorry, thank you.
And I actually think I was on the same flight that you were on. And
Oh,
I switched to Orange
yeah,
County,
oh,
and
yeah.
that's how I got here
Yeah.
faster, so
Yeah,
I
you got here
understand.
quicker. Should have done that.
So we have not got into it.
Okay,
I mean, we've all
okay.
read it individually in our
Okay.
board packets,
All
but we
right.
haven't discussed
Okay.
it.
All right.
So maybe I'll start with questions since I don't hear anyone else. I always like to give other board members an opportunity before I jump into my own. Actually, I'm gonna start with Ms. Finner. Can you explain how you arrived at the staff recommendation?
Yes.
Okay.
So if you look at the different scenarios, A, B, C, and D, A increases it by 50, B by 75, C by 100, D is a cumulative of 100, but it breaks it down into 75 one year, 25 the next year. Basically, looking at the months in reserve, the most fiscally responsible would be to increase it by $100, which is scenario C, which is the basis for staff recommendation. I will point out for the board's consideration that these figures, one of the basic assumptions is that we will spend 100% of our appropriation. So if we do not, if in any given year we don't spend the full appropriation, then the money would be reverted back, and that would give us some additional time. And I had originally believed that they were funding the TRF, all of the scenarios were funding TRF at $300,000, but that's not quite the case. And so you'd have to look at each scenario to see how it funds the TRF.
Thank you. So from the department's point of view, what happened?
And I don't mean to backtrack a little bit, but I don't think I've met all of you, so I just wanted to do a quick, maybe you already introduced me when I wasn't here, sorry, but I'm Maureen O'Connor, a budget manager with DCA's budget office. And so what I can do is just provide a quick overview of the similarities and the differences between the two fund conditions, the ones from January and the ones from this board meeting, if that would help. And then maybe if there's questions after that, because I think that might help clear up maybe some initial questions.
Sure.
So First to start off, right, the differences, there's major differences, but before I go in, I just wanted to go over the similarities, which one that Ms. Fenner pointed out was all the scenarios assume that the board spends its full appropriation. Another similarity is that they all assume that the fee increase will go into effect in FY 18-19, so that's the same across all scenarios from January to this meeting. And they also assume that the board will realize its revenue estimate. So all that revenue you see projected in future years in the fund conditions, so of course that assumes that you will collect at that level. So the major differences between the January fund conditions and the ones for this board meeting packet is, as Ms. Fenner pointed out, the ongoing transfer to the TRF. So the ones in January showed one-time $100,000 transfer in current year 16-17 to the TRF, whereas the ones we provided in this packet show the ongoing transfer. So, and there's different scenarios of where we'd show different amounts and different timing of when those transfers would take place for this board meeting packet, and I can go through those scenarios more specifically. But the main reason, well, there's a couple of reasons, is one, fund conditions are point in time. So they're based on the information we have at that point in time. And the most current information for your fund was the governor's budget. So governor's budget, public information at that point, shows a $100,000 transfer in current year in 16-17. Now, it does not show any future transfers, because if you had built in any future transfer, it would have dropped the board's fund condition, the board's fund reserve below 6 months. And there's a statute that says the board's fund, any transfer to the TRF cannot result in the board's fund reserve going below 6 months. So you can't build in a transfer in the governor's budget that shows a board's fund reserve going below 6 months. So we couldn't show that without it showing a negative fund balance. So that was the main reason for excluding it. And so the ones in this fund condition scenario there's one that shows $300,000 transfer made every year, the specific revenue increase amount. And then there's some other scenarios we show some other options, basically, if you don't assume a $300,000 transfer every year. But I just wanted to point out one other difference. It's pretty minor, but I just want to point it out, was the fund conditions in January show your statewide pro rata costs in 16-17 and 17-18 and not thereafter. So in these fund conditions, we showed the statewide pro rata costs ongoing to make a more conservative estimate, because the goal for these fund conditions and this board meeting packet was to make it as accurate as possible, as up to date with as much information, as conservative as possible too in some situations. So we wanted to show that statewide ongoing, because we know you'll have statewide pro rata, we just don't know how much beyond 17-18, so it's a more conservative effort to include it ongoing. So that was the other difference I wanted to point out. Those are the main, the main differences between those two scenarios, the January and this board meeting packet scenarios. So I don't know if you had any other questions on the differences, but if not, I can go over each fund condition scenario in your board meeting packet individually.
As it relates to the TRF, I just heard the explanation of why only $100,000
right.
was deducted. But if I look to prior years, I had the staff pull out, all the way back to 2008, our budgets. And there were some times when the fund was going to slip under the 6 months. That practice was not done then.
The practice of transferring to the TRF if it resulted in below 6 months?
Right, and not showing that in the report. So how is this time any different than the times before?
Yeah.
And then how can we have confidence that the numbers you're showing us now are valid?
Well, there's one caveat to looking at prior year data, is that you have the benefit of looking at actuals. Okay, so when we look at your fund balance, like I said before, it's point in time. If we're in the middle of a fiscal year, you don't know how much you're going to end up spending at the end of the year or saving. You don't know how much revenue you're going to bring in. And depending on the point in time of that fiscal year, we may have, it may only, if it's only been 6 months, we don't have a lot of data to rely on, so no projection is probably going to be very accurate at that point. Whereas now, what are we in? July, we know pretty much how much the board's going to spend this year and how much the board's going to bring in. That gives a more accurate picture. Now, as far as determining whether or not you can make a transfer with 6 months, in reserve or not, it's point in time also. So let's say in the middle of the fiscal year, we're looking at making a transfer. We would look at, okay, what are we projecting for that fiscal year? Or most likely, if it was middle of fiscal year, we would assume the board was going to spend its full appropriation to err on the side of being conservative. So we'd say, okay, this point in time in January, February, whatever month it is, does it look like the board, if we transfer X amount over the TRF, that they'll still have 6 months in reserve? If the answer is yes, we can go ahead and make that transfer. Now, it could end up at the end of the fiscal year, after you make your transfer, after you've had all your expenses and your revenue come in, that year you end with a little less than 6 months in reserve. That's possible. So if you look back at prior years, it's possible that was the situation where at the time you made the transfer, it didn't look like it was going to result in less than 6 months, but when you finished the fiscal year out, it did result in that.
I think this board takes their fiduciary duty very seriously, and many of the actions that we've taken over the past years is looking at those numbers and deciding when's the right time to do certain things. And the TRF is a very important part of what we do, and the fact that it didn't show up, and we went through this process of license fee increase going to Senator Hill's solace to put these numbers together. And actually in our last board meeting, we already voted on an increase to then come back today at this meeting to say, oops, there's some more numbers that we forgot to give you all. It's really disheartening and difficult. Are there any other questions from the board for?
Do you want me to go over the scenarios that are in your packet today, or?
May I ask a question?
Oh, sure.
Ms. Hurt, you said that you had asked for past financials from 2008 to be pulled. Were those actuals, or was that the format that they had been provided to us at that time?
As I understand it, you can clarify, it was actuals and the format that we were given. So it was both.
It was projections and fund conditions.
Yeah. It was
But the
both.
format had changed this particular time compared to those others when it was just the format, not the actuals?
In my very quick look,
Yeah.
yes.
So bottom line is, in my mind, for the future, we need to have some format that's consistent so that we're not having to guess format from year to year. Because these numbers are so important for our, the CSRs and for everybody in the legal community in California. You have no clue how much heart we put into this, and to get numbers that are skewed or different format that we don't realize is going to affect a huge decision we have to make today.
And just to clarify, when you say format, what format change specifically?
To my understanding, having the TRF funds there,
The transfers?
2008, 2009, 10, 11, 12, 13,
consistent.
Oh,
14.
or just to
And
see
then
the
in
prior
17,
years.
Not to have it is, as you might know, it would be confusing to the board as to why it's not there when we
So,
consistently had it.
yeah, so if I'm understanding correctly, you're saying not seeing the transfers to the TRF in future fiscal years on fund conditions?
It needs to be consistent.
Well, so there's actuals, that meaning we know that transfer took place, and then there's projections and
Exactly,
estimates.
and the projections are what we have to use, because you have the expertise.
Right, right,
To
and
make our decisions for the future.
correct. And we will provide any projections or estimates or scenarios requested of us. We can only put together a scenario with the information we were given at that time.
I agree.
So, and Ms. Fender and I have talked about this at length after this, of how to prevent this from happening again, is just increasing, improving our communication on making sure we're clear, what does the board need, what's the goal of what the request is, and making sure everybody understands what we're providing, so there's not, any confusion. So,
Thank you,
yeah,
that's super
absolutely,
important.
yeah,
A quick
absolutely.
question, do you-
Especially with the TRF, sorry.
Do you ask the executive officer or the board every year what's happening with the TRF and how much should be distributed or not?
So-
is that a question that happens every year?
So there's a few multiple times during the year that may happen. Usually what we do is every month we provide projections for the board's, the main board's budget. We also have a annual budget meeting every year with the executive officer or bureau chief and any of their staff they want to invite to go over the condition of all their fund or funds if they have multiple. And that's an opportunity for both sides to share what's coming in the future. How is the budget built? Is there anything, we didn't know that's being planned? Or are you planning on doing a fee increase? Or maybe on our side, hey, you need to do a fee increase. Looks like a few years down from here, you have a negative. So that's the time for that communication, although it can happen at any time throughout the year. But we were usually providing those projections on a regular basis, but fund conditions are usually provided upon request, like for a board meeting or just for an informational purpose, or for like this scenario of a fee increase. We want scenarios for a fee increase so that time it can be requested as well.
Okay, Ms. Brooding, did you want to add anything?
I had just a point of clarification. So it's my understanding that the projections indicated for a $100,000 transfer when the TRF can be up to $300,000 in transfers. But on average, we've spent approximately $245,000 annually. So I'm just confused. I understand from what I'm hearing, the $100,000 was estimated so that the board would not go under the 6 months reserve.
Correct.
But I don't understand why that much would be budgeted and not flagged if our annual spending is well over $200,000 annually.
And sorry, when you say flagged, do you mean?
I don't know how else to say it. If we have a $100,000 budget for a program that's budgeted at $300,000, there should have been something that flagged a fee increase or some kind of warning ahead of time to clarify that if something isn't done, then it's going to have to stay at the $100,000.
I mean, it could be as simple as an asterisk underneath
Yeah,
that 100 that says
right.
the reasoning for that.
So for the governor's budget, we can't show a negative fund balance. If we had built in any transfer at all, you would have had a negative fund balance. You can't do that in the governor's budget.
But and I hate to interrupt you, but I'm a little frustrated because it's sounding to me that the budget's office made the decision to incorporate $100,000 in there without saying, hey, board, look, we're only putting $100,000 here instead of your normal $300,000.
That would have been presented at our annual budget meeting, the fund condition, the governor's budget.
Just, it's a lack of consistency. I mean, 100,000 all of a sudden, and every other year was different.
So
there's confusion, and it's caused us to have very difficult time making some very important decisions based on those numbers. So
Yeah,
that's what I'm saying.
the last couple of years, there's been no transfer. So there's not a transfer every year. Also, 300 is a max. You don't have to transfer 300 every year. So it's of course, as you know, the board's discretion and at your direction that those transfers take place.
Are you certain that there has not been any distribution these past few years?
Any transfer
Of
over
the- yeah.
the past 2 years, there's been no transfer.
How have claims been being paid?
Well, there's been enough funding in the TRF. There's money in the fund. So if you don't spend it every year, it carries over like any other fund.
I'm not satisfied with those answers. I feel like we kind of need to all sit down together and figure out a solid way of moving forward so that we're all talking about the same numbers. I mean, I think larger boards can absorb this error, but this board cannot. I mean, we run a tight ship, and to hear how we were doing it one way and then it changed to another way, and then
Yeah, I think that's a good idea because I think maybe I need a little more history on maybe there was some way it was happening before and it changed at some point. I'm not aware of it, but I'm more than happy we can sit down and go over what's taken place in the past and what needs to be done moving forward. Absolutely.
And I don't want to beat a dead horse, but I take, like Ms. Hurt said, our fiduciary duty and responsibility to the profession and the consumers very seriously. And the reality, I mean, I'm just going to break it down, is we were faced with a fee increase. We had that conversation in January. it was painful, but we increased the fee. And now we're back here again because of I'll call it an irresponsible and significant omission by your office to not give us the information that we needed in January to consider the initial fee increase. And now we're here again a second time, and we look like we're irresponsible, and we are faced with another decision to increase the fee when we could have had this conversation holistically one time and had all the information from you as a professional to this board. It would have been much more substantive and much more productive. And so I don't want to look like this board is raising fee increases irresponsibly 2 times when we're here because, like I said, of an omission from your office. So we need to rectify that going forward because I don't want to have this conversation 2 times in 1 year.
Yeah, I'm
That's
in
it.
agreement that going forward, it's absolutely imperative to prevent this from happening again. I mean, I hope not to, keep looking back at, whose omission it was and why the omission happened. I really want here today, and I mean, at your discretion, to help you guys with whatever is the best option moving forward for the board. I mean, whatever you guys want, we can work with you on it. Whatever needs to happen in the future, absolutely. I mean, we're here to provide you whatever information you want, anytime.
So this board looks forward to working with you because
Okay,
we're
great.
going to need to take care of the future of the fund as well as our budget.
Yes, absolutely.
Sure.
I was just going to make a clarification for the board. So at the January meeting, we had voted to increase fees, but not to have them effective until basically next fiscal year. I want to make it clear that it hasn't been raised yet. So basically, we are starting from scratch. It won't be 2, one on top of another. So just pretend January didn't happen.
Okay.
We're trying, but it's rough.
Money and time
I
is
I just want to be really clear that we're not making 2 fees or
Yeah.
2 increases.
Good clarification.
Yeah, just.
Yeah, thank you. So, Ms. Brody,
You
did
voted
you?
to change them as of January 1st, I believe, which I don't believe is considered the fiscal year. I think it is for January.
It was the middle of the fiscal year,
Yeah,
yes.
middle of the fiscal, yes.
Thank you for that.
Okay,
So
thank you
would
for
this
clarifying.
potential change be effective immediately? Is that what you're, okay,
Or
sorry,
need to.
I'm ahead of myself, or what?
Well, our new staff council has informed us that we do need to go through the regulatory process. So that's going to delay things a little bit.
How
So,
little?
so do we have a sense that we can,
As fast
that
as
we
we can
can
get through.
depend on these numbers? I mean,
I think we don't have a choice.
we have to depend on these numbers and assume that these are accurate. Even,
Yes.
So
I mean, we have to go there, right?
I would propose that the board take the numbers for face value, knowing that Davina and I will have follow-up meetings with budgets. And if there are any changes in numbers, that we would bring them back to you so that adjustments could be made.
Okay.
Yeah, because I'm not satisfied with where we are, and
No,
I'm
it doesn't,
gonna-
I don't think any of us are particularly.
so I'm going to work with Ms. Finner and the Budget's office and bring something back to this board. that
Okay,
we can be
because
comfortable with.
I support everything that people up here have
Yes.
said, and
I do too.
okay.
So we have scenarios before us, A, B, C, and D. Many of which still keeps us under the 6-month reserve. So, are there any other questions of Ms. O'Connor before we kind of dig into the discussion of what we think is the best scenario? No? Okay.
Thank you.
Thank you.
Okay, yeah. Do you want me to stay in case any questions?
Yeah, I think that would be helpful.
Okay.
Yeah, just
Yeah.
if through our discussions,
Sure.
yes. Thank
Yeah,
you very
no
much
problem.
for your time.
Thank you very much.
Thank you. So my perspective, scenario C is the only one that really works, although I like the concept of scenario D, and we just do a little bit of an increase and then more. But as I said, it still does not
doesn't
take us
s-
above the mark. That's important. So, and it's also important to note that our fees are increasing, not just for TRF, but our salary, our costs have gone up, cost of living has gone up. Our pro rata shares have gone up. So there are a lot of things that we've had to take into consideration for this increase.
I did ask Marina to do a little bit of research, and she did say that looking back, our expenses have increased sharply,
Yeah.
and that our revenue has been slowly decreasing as people retire. So it's kind of a
Right.
double whammy there.
Right. So, any other thoughts on what scenario appeals to
Well,
folks?
it's not appealing. But, I mean,
Trying to put a bow on it.
raising fees $100 to me is just like painful. Sorry, I know it has to be done, but and the only scenario that works is C. But this is really painful to me.
Okay.
I think we
And
all
this would
echo-
go into
echo that.
effect
We're all sad,
Yeah.
next year.
but we have to move forward.
So, council, when would this go into effect if we were able to make a decision today?
Making the decision today then would trigger the first part of the regulatory process. Your EO and I would be working on a regulatory package to put forward the fee, to put together the fee. That then goes to DCA's Legislation and Regulations Office. They make sure that it's in basic compliance. It then goes back to my office for review. If I'm working on the project up front, then we can shorten some of that review because it won't stay on my desk but long enough for me to sign off on it. It then goes to general counsel for their review.
Okay.
Every review that legal does is to make sure that we're in compliance with OAL standards for adopting regulations. That includes sufficient documentation of fiscal need for a fee increase. So we would be working towards getting all of that information basically perfect when we submit it for review. After DCA legal counsel, general counsel reviews it and signs off on it, it goes to the director's office. Director's office has to review and sign off on it. Then it goes to agency. Agency has to review and sign off on it. There is no standard for control over how long those processes take. I can give you estimates both on the short side and the long side, but in general, a package that gets hung up will get hung up as long as it gets hung up.
Is there any way to put like an emergency label on the reg?
So there's not a way right now, at least as far as I'm aware with budgets, they're not in, if there were no transfers to the TRF, the fund is not insolvent, correct?
If there were no transfers to TRF.
Could you come forward to the mic, please? Thank you.
If there's no transfers to TRF after this year, is that it won't be insolvent, that's correct.
So if there was an insolvency built in based upon your general need for increases, salary increases, healthcare increase, cost contributions to retirement, all of that stuff, your pro rata, all of that stuff, and there was an insolvency, then you would be in an emergency situation because you cannot carry out your statutorily mandated duties of licensing and enforcement without the necessary funds. So if we were in that circumstances, we would put an emergency label on it. We may even move the regulation as an emergency regulation. However, I have already spoken with general counsel. He is aware that this is a very high profile and complex situation based upon erroneous information previously given to the board by the department, that the TRF is a high profile fund, has great impact on access to justice, and that we will internally be moving it at an expedited pace, treating it as though it were an emergency so that the board can put itself back into a good financial house and move forward knowing that
moving forward, you will have sound information. So I have been, knowing that this was coming up, I have been speaking to people that need to be spoken to, and I can't promise anything, but we will treat this as one of the more serious packages moving forward. I have to tell you that if we get a statutory mandate regarding any of the healthcare situations, they would trump. So if we have regulations that deal with immediate jeopardy to life, this package would drop because it's a fiscal package.
Yeah.
But absent something like that, everybody who needs to be informed has been informed.
Okay. And not to put all this, to put you on the spot, but I remember at our last meeting, it was talked about that this could be done through a resolution from our other staff attorney. So could you update us on what has changed where this can happen via resolution?
So there are some boards in the department that have authority to set their fees by resolution. In order to set your fee by resolution and not have to undergo the regulatory process, there are two sets of languages that must occur in your Practice Act. There must be language that says that you can set by resolution, and there must be language that says that the board is exempt for setting fees from the APA, the Administrative Procedures Act.
Okay.
Your board has the resolution language. Your board does not have the APA exemption language.
Okay, so we have work to do.
Yes.
Okay, so any public comments on this agenda item? Okay. Any other discussion?
I have, so, how soon could we even remotely think of having this new fee set go into place?
I would tell you about this time next year, unless miracles happen.
All right, so I'm looking here, where are we going to be financially this time next year?
So we would be looking at the beginning of fiscal year 18-19. That's actually, it looks like that's where you projected the fee to go into effect.
Right. Right. Exactly, my point. You're catching it. Thank you.
So we also still have a lot of work to do with budget, so these numbers may change a little bit.
I get that, but I also see that the clock is ticking and the money is going down. And
So we have to make a decision today.
Well, to me, we have to do something.
Yeah, so the decision has to be today. So I voiced scenario C. I think I heard one other scenario C, two others.
See.
Yeah.
Just so that you're all clear,
Yeah.
the scenarios that you have here have the fee increase in red. Those fee
Yeah,
increases
right.
would be effective with fiscal year 18.
Right, July
correct?
1st.
So you're anticipating that the fee would be in place not prior to July 1 of next year.
Right, correct.
Okay. So and I
okay.
think that on the outside of possibility that's doable.
Okay.
And sorry, you can correct me if I'm wrong here, but is it possible for them in regulation to say effective upon approval of the reg package so that it goes into effect earlier if they wanted it to go into effect earlier?
In days gone by, that would have been pretty standard language for something like this. There have been changes, regulations go into effect quarterly now, unless you get an exemption. That will be something that we will be seeking at the beginning of the process, so we will be telling agency and the governor's office that we are going to be seeking that exemption now, rather than waiting until the end.
Okay. Okay. So would someone like to make a motion?
May I interject and suggest or ask if the language of the motion can say that the fee be put into effect as early as possible?
Absolutely. To the person who will make a motion. Do I hear?
I move that we move forward with adopting scenario C, which would increase the fee by $100, and that we
Put into places.
put into place the ability to charge this fee as soon as possible.
And
Or-
auto-
and authorize
And
it. Or,
authorize the executive officer to commence the regulatory process.
got it. Whatever she just said.
Could you repeat it?
Oh, does that mean?
Paula, do you have it?
Okay, I move that we adopt scenario C, which would increase the fees by $100, that we ask for language that would give us the ability to enact this fee as soon as possible, and that our executive officer can begin the
granted the
regulatory process.
Is there a second?
Second.
Okay. Public comment again? No. Okay. Any further
Everyone
discussion?
hurts. I'm sorry, it hurts.
Okay, seeing there are call to vote.
Ms. Crum?
Yes.
Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes.
Motion carries.
And I know that that's a sharp increase.
I'm sorry.
And the board understands that, but we look to the future and the possibility of that decreasing. We will always evaluate and look at those numbers. All right.
Can we take any of your afternoon session?
Did we set a time?
We did.
But we didn't say which ones were gonna be in what.
We set a time for the meetings, but not any specific item as time certain.
Then you may continue with the agenda as you see fit.
Then I would suggest,
We hop to 7.
Number 7?
Oh, wait, hold on.
Sam pass rates is the next one.
I would go to 8 or 9.
Sorry, we're going out of order?
Yes, we
Yeah,
are.
I just for the board's benefit, the two items, 6 and 7, the exam pass rate and the online skills exam task force report.
Mm-hmm.
I have informally spoke with students and teachers and told them that we would not talk about those until right after lunch.
Oh,
In
okay.
order for them to be able to travel this morning, it's a travel day for many of them. So I would like us not to address those two items until 1 o'clock, we'll take them up first thing after lunch, but just to give them the opportunity to be here, just as a courtesy.
Yeah, I think that's a great idea. So we will skip to agenda item 8, which is our strategic and communications plan.
So what you see before you looks identical to what you saw in January, because we've been busy.
Yes.
I don't mean to make light of that. It really has been an extremely busy time at the office. We do have a number of complainants that are time consuming. And so that takes away from staff time for the regular work doesn't go away while we're dealing with some of the people that are a little bit more needy time-wise. We're very conscious of what's left to do on the strategic plan. We would hope to be there. I think with this particular CSR, we will be back on track. We really did have a lot of cleanup, having January and March tests back to back, did put staff behind overall. I think that we will be back on track after this particular CSR. So I would expect work to kick in again on the strategic plan.
Okay. Any comments from the board?
Always an opportunity for the board to change our priorities. I mean,
Yes.
what I'm looking at staff accomplishing next would be the website task force meeting and starting that overhaul, as well as a lot of the cross training, which is going to take a lot of time staff-wise, but is critical.
So those are my top 2 on my list.
Perfect.
So
I
we're
like
in
when
sync
my
with
list
that.
matches your list.
The website as well as the cross training, because we are such a small board, and being able to keep business moving forward with multiple people working on multiple tasks.
And just
Sure.
Rosalie and Tony were the website subcommittee, so to speak, or task force, so you guys will
Come out of suspension.
Can't wait.
expect to be contacted.
Our website needs it, so.
Yes.
Okay, any other priorities folks would like to?
No, I would just like to compliment staff, because I know you all have been under incredible pressure. And I really do appreciate, and I know that the board does, we really do appreciate all your hard work. And I know that you work under a lot of stress, and it's not always fun and pleasant, but thank you very much for your hard work.
Yeah, I would like to echo that as well. I mean, every time I call, they're right there, ready to work, ready to have an answer and get to us with all the things that we need. And it's a great benefit, and we're all very thankful.
I would really like to recognize staff because we are very small. So we have 2 half-time and 3 full-time in addition to me. So the fact that we can keep the office open, answer phone calls as much as possible. We answer other questions from other people's desks. We might not be able to get every specific status from every specific claim, but given our resources, and the spirit in the office for people covering for each other, it just is, I think they should be recognized, and most of them are here today, and so I just want to publicly say thank you guys for such amazing work.
Thank you all. Okay, that was a fast agenda item. If there aren't any other comments, no? Any public comments about our strategic action plan timeline? No? Okay. So that will take us to agenda item 9, which is the election of officers. So this is the election of chair and vice chair. On an annual basis, at our first regular meeting of the board after June the 1st of each year, we conform to the policy of voting on a chair and vice chair. Are there any nominations for chair?
Yes. I would like to nominate Davina Hurt for another year as president. She has done a wonderful job. I admire and respect her work and would love that she serve another term as president.
I second.
Thank you.
That was fast.
Yeah.
How can you turn that down?
It's been a pleasure and a joy to serve as the chair, let me tell you. So I look forward to another year. Are there any public comments? No. Should we take a vote? Yeah.
So you accept then?
Yeah, I do. You don't see any smoke going out the door.
I'm just teasing. I just want that on the record. Ms. Crum?
Yes.
Ms. Lisinski?
Yes.
Ms. Nocella?
Yes.
Ms. O'Neill?
Yes.
Ms. Hurt?
Yes,
Motion carries.
happily. Okay, so that takes us to the vice chair election. Are there any nominations? And actually, yeah, are there any, could you give us a bit of a detail so that everyone understands why I'm hesitating?
Sure. So we did hear from the governor's appointments office, and they are a little bit backlogged with boards that are facing quorum issues. And luckily, we are not in that position. But we do have 2 board members that are serving in their grace period through the governor's office. That would be our 2 licensees, Rosalie Crum and Tony O'Neill. So technically, in your grace period, you would not be eligible to serve in any of the elected positions as officers. So you would not be eligible to be nominated as vice chair.
So please do not nominate me. It's
So
against the
that
law.
narrows the pool.
Just slightly.
Yeah, just, the paper, rock, scissors thing.
So do I hear any nominations?
No. Don't you Carrie, don't you?
Would you like to nominate Carrie?
I would love to nominate.
Go quick.
But Rosalie, you're not eligible.
I'm not allowed to
She's not.
because I'm in a grace period. Governor Brown has not reappointed me yet. He's
We'll get her in a
considering.
year.
Would you?
I'm happy to defer to a more tenured member
Uh,
of the
oh, no.
board who would love to serve as vice chair.
Okay, I'll do it, but your turn is coming, I'm telling you, very quickly.
Why does that sound like a threat?
I know.
It's super fun being vice chair.
It is not.
I get to harass you with phone calls?
Davina gets to do it.
Go for it.
I hereby move to nominate Elizabeth Lisinski as vice chair of the California Court Reporting Board.
Your turn is coming, I'm telling you.
I second.
Okay. Public comment? No? All right. We'll take a vote.
Ms. Crum,
Yes.
Ms. Lisinski.
Yes.
Ms. Nocella.
Yes.
Ms. O'Neill.
Yes.
Ms. Hurt.
Yes.
Motion carries.
All right.
You're gonna get yours.
We're actually moving really quickly.
I
through
know,
this,
I know,
act.
surprisingly.
Because you
I'm
are so
very
efficient.
surprised.
Yeah.
Let me, do you think that closed session could be done in time?
For lunch?
It's 40 minutes.
Yeah, we have 40.
We have 40 minutes.
I think we could do it. We're super efficient.
I don't see why not.
Okay.
Do one favor.
So
Okay.
if the board would like, I think we're going to, so what is the proper process? So
You
I
would
would,
adjourn into closed session.
there we go. Okay.
You
so-
get a longer lunch.
We'll just need a moment to allow our audience to exit, as well as our television specialist.
Perfect. So, and then we're slated to come back at what, 1 o'clock we were planning?
Yes.
Okay. So we will adjourn to closed session and be back at 1 o'clock.